Okay, so officially, good morning, class. This is now supposed to be the third class of evidence. We are dealing with the introduction to evidence law. Then we are dealing with section 5 to 16, which was dealing with the type of evidence that's admissible in court. When does court admit it? When is evidence decided to be relevant or irrelevant? And I told you that is important because since your case is dependent on the evidence you adduce, how you adduce it and whether it can be adduced or not is very important in any case. Otherwise, you can lose your case from the word go just because your evidence was not tendered properly or was rejected by court. From the last class, you've seen that evidence may be rejected as a matter of fact or it may be rejected as a matter of law. There are some situations where a court will say we cannot accept that evidence, or there are times the evidence will be rejected because of the way it was tendered, like the way it was kept, where it was kept, how it was brought to court, and that is important. So now I want us to look at some specific aspects of evidence law, and the first one is the state of mind or bodily feeling. We dealt with it briefly in the last class, but want to go a little bit deeper in these provisions. So, state of mind or bodily feeling is provided for. I hope you people all have downloaded the Evidence Act. It's provided for by Section 13 of the Evidence Act. The state of mind or the bodily feeling of the person who is in court, either the plaintiff or the defendant, is important sometimes and may be admitted in court. Court will accept it because it tries to explain why a crime was committed or why a certain person acted the way he did. So the main thing about Section 13 is since in criminal cases, mens rea is important, isn't it? Remember, in criminal cases, to be liable, you must have mens rea, the intention, and you must have done the act, and these must coincide. You remember the cases of R versus Smith and all those cases. Now, in torts, which you're doing, I think you're doing nature and history of torts. In the law of torts, which is civil remedies civil liability for actions which have been done. Whereas you prove intention, mens rea in criminal cases, here you may look at aspects of knowledge or even negligence. Like in the law of torts, apart from actual knowledge, you can be liable if someone can show that you should have known that what you're doing is wrong. For example, a person who is at Victoria University in second year should know that crossing the road while texting on phone can lead to an accident. You can be knocked. Whereas a child who is in P4 or something may not necessarily know all that. You get it? So the state of mind becomes important. So under Section 13, if you can bring such evidence to court, it will be admitted. You're going to learn this later on, but like in cases of assault, in cases of battery, in cases of false imprisonment, all these cases which you're doing in your nature and history of tort, if the person had, for example, he was angry and he was shouting and wanted to fight, he threatened to beat someone up, that would be assault. If the person actually touched the other person with an intention to harm him, like in battery, then that you'd be proving battery. So you show the state of mind. Remember, battery does not have to be a physical thing. Doesn't have to be violent. You can actually touch someone without violence. You may touch him in a certain way, but it will still amount to battery. So you look at the state of mind. And the state of mind will always bring out the kind of defense that I did not intend it, it was an accident, it was unintentional, and things like that. And that is that's how it helps. 2, on state of mind, sanity is important. Sanity plays an important role in determining liability. You very well know that in criminal law, sanity is relevant to prove guilt. You must prove that someone was sane when he committed the offense. In fact, you have the defenses, you have intoxication, you have diminished responsibility, if you remember those things in criminal law. So sanity is the state of mind of the person at the time of committing the offense. This would be admitted because it can prove whether or not the person committed the offense, or whether the person has a valid defense. Also, in succession matters, like I talked in the video before, sanity is relevant when you're trying to determine whether a will is valid or not, and also in other cases. But I won't go so much deep into the different ones because you will deal with them in the law of tort and the law of negligence. The knowledge itself is important, like I've told you, because knowledge is the one which helps you understand what were the people trying to do at the time of the act. If it's the law of contract, remember the law of contract is a meeting of minds. So where both of you had the knowledge of what you are contracting for, then a contract would be valid. But where there was mistake, you remember the law on mistake, vitiating factors of a contract in your 1-2, where there was a mistake of fact, you thought you were buying a Nokia phone, the other person thought he was selling you an iPhone. So the knowledge at the time is important. So you can bring these facts. This can be admitted as evidence under section 13 to show that this contract should be terminated because at the time of contracting, both parties, the knowledge of what was going on was totally different. Yeah. So I want you look at, anyway, you're going to discuss these cases, but the case to look at is the case of R versus Godfrey, where an appellant was convicted. It was a traffic offense, and the issue was whether he knew what he was doing at the time. In this case, he had taken alcohol, and he had taken a certain amount of alcohol. So the evidence being tendered by the prosecution is that he had consumed a certain amount of alcohol before driving the car. Therefore, this could be admitted to show that he drove under the influence, which was an offense under the act. So that was admitted. Then you look at the case of Kiwanuka and another versus R. I'm going to give you these cases on the list for discussion, where there were issues of defamation. And the purpose of this was to show that at the time of publishing the act, the person who published it intended to attack the other person or to destroy the reputation of the other person. There was malice. So the state of mind at the time of the defendant was that he was malicious. They had an argument and he wanted to be malicious. That's how it was admitted. Then you look at the case of Akrabi versus R. I've summarized these cases, but you're going to look at them deeply and discuss them. So you look at the case of Akrabi versus R, and in this case, the headmaster was being charged with, he used certain kind of force, an illegal force, to molest, some two boys, children. And the only evidence that was there was that the children were saying that he did this to us, he did this to us, he did this to us. There was no other corroborating evidence. We shall deal with corroboration later. But the state of mind, when he was saying, I'm a headmaster, how can I do this, how can I do that? They could admit evidence to show that the person, even if he was saying he was innocent, evidence could be shown that his state of mind while doing these acts was actually to molest the children and not to punish them or do anything else. So it was being used to try to explain why the person should be found liable. Any questions on that? Or I can move them, you shall ask the questions later. So that's the first one. The second thing we are looking at is similar facts or occurrences. Remember, we told you that in the previous class I talked about facts which are admissible in court, and we talked about past, present, and other occurrences that can be admitted in as evidence. So under section 14 of the Evidence Act, similar facts or occurrences can be admitted. So this is almost similar to the previous one, but in this case, similar facts or occurrences are admitted to prove that certain acts were not accidental or they were kind of intended. So where there is a question of whether there was an accident, whether someone intended to do something, whether the person had no bad intentions and things like that. You can adduce evidence of similar facts before to prove that what is in court is actually true. This person really had the intention to do what he was doing. You look at the various cases, but the first case to look at is Makin versus Attorney General of New South Wales. Makin is M-A-K-I-N. You'll see it in your reading list. This is where courts looked at the aspect of similar occurrences. Now, what I want to be clear is this: when you're trying to, like in a criminal case, if someone has been charged with rape, you do not bring evidence of him stealing in another case, that he was convicted of theft in another case, he was convicted of armed robbery, he was convicted of maybe conspiracy, whatever it is, or theft or murder in another case. The facts in issue, remember what I discussed about facts in issue and the facts? The principal facts is that he raped someone. What is important to prove is that maybe he has raped someone before, he has done that act before, and in certain similar circumstances he has done the same. He normally does it like that. So for example, for serial killers, you can bring evidence to show that on 3 occasions before, he has kidnapped someone, locked them in a bedroom and killed them before, and that will be admitted as evidence to prove that he should have done the same thing in this case. So for similar occurrences, they have to be somehow related to the facts in issue. They have to be past similar acts, and they are only acceptable if they relate to the facts which are in court, before court. I hope that's clear. So you look at the case of R versus Smith. Someone was charged with murder of a woman, and they found the woman who had been drowned in a bathtub. And he said, it's an accident, she must have fallen in the bathtub, I don't know what happened, and all that. He kept saying that she had epilepsy, epilepsy and Simbu. And so she fell in the bathroom and she died. But then evidence was admitted showing that 2 other women in similar cases had died in bathtubs, they had been drowned in the bathtubs, and in all those cases, the women had made financial arrangements in his favor, like they had made arrangements to pay him or things like that, so that he can benefit from them in case they've died. So these similar occurrences before could be admitted to show that in this third case, there was a high chance that this person also who had died in the bathtub had died under similar circumstances. Have you got it? The next case to look at is John McKindy versus R. The other one was Makin versus R. This is John McKindy versus R. In this case, he had been beating someone before, and he had been beating the person before. So when the person died, finally, they adduced evidence to show that he had been on previous occasions beating this person almost to a point of killing them. So it meant that the previous beatings could be admitted to show that in this case, he must have actually beaten the person the same way he had been beating them before, and thereby caused the death. So you look at the other cases which you're going to discuss. There is Mood Music Publishing Company versus The Wolf. There is Harris versus DPP. These are the cases I'm going to give you. I'm not going to go to them so much because we are going to discuss them. And then there is R versus Scarrott. Then there is Hales versus Carr. Well, I'm going to give them to you in the group. So those cases show that where there have been past similar occurrences, they can be admitted in court to prove that what has been happening this time is not an accident or was intentional. Now, the third thing we are looking at is hearsay evidence. I'm sure by now you've heard of hearsay evidence. You've heard people saying that's hearsay, that's hearsay. Like I told you locally, it can be referred to as Lugambo, but Lugambo may be different because, but still, when you hear something and then you talk about it to other people as if it is you who said it or who had it, then that becomes hearsay. So this is provided for by Section 60 of the Evidence Act. Section 60 of the Evidence Act states that the things must be proved by a person who actually conceived those things. And conceiving them means you should have seen. So if you saw someone running out of the house, you must have seen it yourself. Not that you were told that by someone who saw that so and so ran out of the house. If it's hearing, you must have heard the thing yourself. If it is smelling, you must have smelled the thing yourself. If it's touching, you must have touched and felt the thing yourself. So you must have conceived it with your own senses. So under Section 59 of the Evidence Act, the law only admits direct evidence of whatever was happening, and there is no hearsay evidence. It will be excluded. So from our previous class, it means on admissibility and relevance, hearsay evidence will not be admitted in court. It will not be admissible in court, of course, until we get the exceptions. So hearsay evidence may be oral or written. So where it is oral, someone told you something, it must be you to testify about what you were told and not anyone else. When it comes to written evidence, if there is a document like a contract, the primary evidence is the principal evidence is the contract. You cannot again come and explain what was in the contract. I'll give you an example. Just last week, when I missed class last week, we had gone to Dokolo, and someone bought land from an old museum, and the museum's the contract said, "I have sold you my garden. I have sold you my garden." Translation from their language: "I have sold you my garden." This is about 14 years ago. Now, when we went there, the person came back arguing, saying that I did not sell him all my property. I only sold him a few meters of the land. So now there was a valid contract saying, "I so and so sell to you my land in exchange for 3 cows, a bag of cement, and so and so," and that was the contract signed with the LC. Now he's here in 2022. He's saying, "I only wanted to sell him the part which had matoke, not the other part." You get it? So, and now the people who are arguing that are actually the person who is arguing that is the one who sold. So now it also becomes like hearsay evidence, because the contract is valid. It's saying what was exactly what happened on that day. Now you're trying to tender in oral evidence to change what was in the contract. So this could not be admitted. The second aspect of hearsay evidence is the statement in point must have been made by a person himself who is not in court. So if the person is not in court when the statement is being made, so and so said this, said that, it will amount to hearsay. And then the purpose of the statement alleged to be hearsay must be to prove what was said or written. It's the purpose of why someone is saying that is trying to prove something else with oral evidence, and that would amount to hearsay evidence. So I want you to look at the case of Chandvasekera versus R. Chandvasekera versus R. It's a 1937 case. It was a murder case, but in this case it's interesting because evidence was given that the person who had been murdered, before dying, they had cut her throat. But just before dying, they were asking her questions. What happened? Is it this one who did it? What happened? What happened? And she would either shake her head or nod her head because she couldn't talk. And the issue came in court. They asked, was this admissible or was it hearsay evidence? Did this amount to hearsay evidence or could it be admitted? And it was held that this was an exception to the hearsay rule because it amounted to a dying declaration. We shall deal with that shortly. And it was the mode of communication. So it was not hearsay because the people who witnessed her saying the statement actually got the evidence from her, so they could give this evidence as a testimony that she told us that so and so is the one who cut her. When we asked her, she nodded her head. When we asked whether it was Jack, she said no. When we asked whether it was Jill, she said yes. So that could be admitted. Yeah. So you look at the case of Subramaniam versus DPP. Subramaniam versus DPP. You look at the case of R versus Gibson. You look also at the case of R versus Sparks. This is where a white man, Sparks, was indicted for indecent assault of a girl. She was, I think, 3 or 4 years old. So, after the assault, after the indecent assault, the young girl, she was young, she was 3 or 4, she told the mother that it was a colored boy who had assaulted the victim. And the defense was saying, how can the mother give such evidence? It can't, that's hearsay evidence. Repeating what another person had told her. But and court at the first appeal, at the first trial, court convicted the person, saying, since the mother said it was a colored person, someone with color, then you are liable. But on appeal, this was set aside on grounds that the mother's evidence was hearsay, because she said, I was told by the girl that the person was like this. The right person to say this should have been the girl in court, not the mother. I hope that's clear. Then you look at the case of R versus Turner. So I want us to look at, I don't like this preaching, but since I don't know if you've read, if you had read, I would have asked you why the hearsay rule is important in court. But for purposes of time, let me just go through it quickly. We'll discuss it in class. So, why the hearsay rule is important? What are the reasons why it's important? The main important one is that you cannot cross-examine the person who they are saying made the statement. If you say, like in the case of the girl, like in the case I've told you of R versus Sparks, you cannot cross-examine the person to establish whether the statement is true or not, and that is important in court. So that is the first rationale. The second one is that normally in hearsay there's a likelihood that the original statement may be distorted. Someone might say, I was running, he was running away, then the person comes and says, he told me he was moving away very fast. So, is running the same as moving away very fast? You can be walking very fast, you know. Someone can say, immediately I saw the person, I drove away. And then for you, when you come to court, you say immediately after the accident, the person said he rode away, he went away on a motorcycle. So that makes it difficult. So there's a likelihood of distortion. That's why hearsay evidence is not normally allowed. The third one is that there's a likelihood that there will be you can't judge the perception of the person who made the statement. For example, normally in criminal cases, you'll do it in your criminal liability. You may want to prove that you had someone shouting in the middle of the night, and from the sound of the shout, the person was in danger. You get it? So you'll say, we are neighbors, and I had Jackie shouting in the middle of the night. And then I knew, so when I woke up in the morning and I found her dead, I knew that she had been beaten or she had died because of what happened at night. So this will not be easy. You will not be able to judge the perception of the person at the time. You could find she was shouting for other reasons. For example, you're all above 18. So sometimes it is well known that women may shout for a certain reason, as you know. So in that case, the perception will have to be determined. If, for example, it is a rape case, how will you know the type of shouting the person was making to be sure that the person was forced sexual intercourse, for example, or not? And that is the purpose of throwing out hearsay evidence. The fourth one is that sometimes meanings change. So you might have the meaning of a word which was said by another person. It could have meant something else, and then the person who is testifying it in court will say something else. So hearsay evidence tries to avoid that, to make sure that the same meaning is attached. This is common, especially in English, not in vernacular. Words may mean words may mean the same thing. May mean this different words. Different words may actually mean the same thing, or one word may mean something else if said in another way. So someone may say he beat me when the person means he tapped me, something like that. So to make sure that you can cross-examine someone and ask him, what did you mean by saying this? That's why court refuses to admit hearsay evidence. And then normally hearsay will also lead to protracted legal litigations, because you're trying to argue that wasn't me, that wasn't true, blah blah blah. So it will not lead to quick conclusion of cases, and that is why court will reject it most of the times. And of course, lastly, hearsay evidence can tend to surprise someone, because in law you're not supposed to surprise the other party. You remember you've done administrative law, the right to hear the other side. Also, you've done constitutional law, under the Constitution, the right to hear the other party, right to a fair hearing. So this avoids ambushing someone. So if you to go to court and someone is just talking, then he says, I had this one, I had that, it would lead to unfairness, and that is why court will not allow hearsay evidence. So now I want us to look at the exceptions. When is hearsay evidence admitted? When may it be admitted? There are certain cases where even if the person himself is not in court, that evidence is admitted. And the very first one is lying declarations under Section 30 of the Evidence Act. Statements which are either written or oral, which are made by a person who is now dead, they can be admitted if they are tendered by the person to whom the statements were made. These are statements which show the cause of death, the circumstances of the transaction, the circumstances of the things which led to the death. These facts may be admitted. You look at the case of Jasunga versus R. You look at the case where it was held that although that evidence is admitted, it has to be corroborated by some other evidence. So, if someone says, if Mary is dying on her deathbed, and they find that she's weak in the hospital, and they ask her what happened, and she says, Victor who came to my office, it's Victor who came to my hostel, power was off, we were having a proper discussion, he started touching me when I refused him to touch me, he got a knife from nearby, threatened to cut me. When I tried to fight, he stabbed me on the neck. So, if she dies after that, that statement will be admitted, but court will corroborate it by finding certain things. Remember certain things we talked about in the previous class, like Victor's conduct after the crime was committed. If they find blood on Victor's arm, they find him with a knife, he hid it, they find stains on his. So something will corroborate that statement. So the two combined, if now Alan says, when we had us screaming for help, when we went to the room, we didn't find anyone, we only found her bleeding from the neck, and she told us that Victor is the one who stabbed her. Alan's statement can be admitted because it was a dying declaration by the person who made it, and it will be corroborated by Victor's conduct. You look at the case of Mibinga versus Uganda. That's the first exception, dying declarations. The second exception is statements which are made in the ordinary course of business. If statements are made, this is under Section 30B, if statements are made by the deceased person or by any other person in the ordinary course of business, they may be admissible as a rule, as an exception to the rule of hearsay evidence. And these are statements which are made, for example, during work or by someone's capacity as a profession. Such statements, they may be admitted. Such statements must have been made, however, before the dispute arose, not after. So for it to be admitted, as it has to be ordinary course of business, like things you are moving normally. And for example, if a company was operating normally and accounts were being made. Every month they were filing statements, getting bank statements, doing their accounting things, whatever it is. And that person is killed, and before he, as he's dying, or maybe he's imprisoned or whatever it is, the person tells you that, do you know that in our department someone is still, I've discovered they're stealing 100 million, and this is the process I've come I've used to find it. Those statements which were made at that time could be admitted at a later time if there's an aspect to, if that aspect comes into issue, it becomes a facting issue. But they should have been made when the person was not anticipating that thing, and they should have been made in the ordinary course of business. Then statements which are made, if a person makes a statement and it's against his own interest, pecuniary interest, under Section 30C of the Evidence Act, that can be admitted. Because remember, it is something which, the question is, if someone tells you, it's hearsay, but someone tells you that he makes a statement saying maybe the person is dead, but then the statement which is being made takes away a right from that person himself, it may be admissible. Like, for example, someone died, and the vehicle, before transferring the vehicle, or before transferring the vehicle to another person. So if the person says, yeah, he died and he told me that the vehicle which I have belongs to Ismail or Ishmael, that statement can be admitted, because the purpose is to find out whether it is true or not. And now the person is saying that the car does not belong to him, it belongs to another person. So there is no interest he's getting from lying or getting a false statement. You get it? So that under that act, if you're giving away a pecuniary or proprietary interest, then it may be admitted, of course, subject to corroboration and things like that. In criminal cases, if a statement is self-inculpating, if it is incriminating to you who is making the statement, it will be admitted. If it is self-exculpating, if it's a statement which is trying to show your innocence, it will not be admitted. And that's the same justification, is because why would you lie when you're putting yourself in danger? That's when it will be admitted. But remember the aspect of corroboration, subject to the exceptions also. Yeah. Then another exception, the fourth exception, is statements which concern public or general rights. These ones can also be admitted if the person is deceased or cannot be found or cannot be brought to court, but his statement tends to establish a general custom, a public right, or a matter of public interest. This can be admitted. If I see now Justice who appear where he has died recently. So if he made a statement which talked about some kind of rights in terms of how court handles like a bail application and things like that, that could be admitted because it establishes a certain public right or a matter of public interest which is important, and it will be admitted. Such a statement would be admissible if it was made by the person who is not around. Also, a statement which relates to, we've not done this in land law, but we'll deal with it, an easement or a right of way. He says that, no, that's where people used to pass, or that's where people should pass, things like that. It could also be admitted if someone is saying what the other person said before he died or before he disappeared. The fifth exception is that statements which are made in relation to the existence of a relationship by blood or by marriage under Section 30E, they can also be admitted. You can bring evidence to show that so and so is my cousin, so and so is the cousin of so and so, and the person died. So someone can say, I was told that he is related to so and so. But of course, later on, you may have to carry out tests and things like that. But it can be admitted because it establishes a blood relationship. Such declarations must have been made before the proceedings anticipated where the proceedings before court were made for it to be admitted. So you must have made a statement, for example, in matters of succession, that so and so is my child. So if the person dies, in court they can admit that evidence to say that he told me that these are his children, and it will be admitted. if it establishes that relationship. Of course, you will corroborate it with other aspects. You can even do DNA these days. You look at the case of Harris versus Gaffey. Then statements made in relation to a will or a deed under Section 30, of course, will be admitted, because in a will or a deed, if it exists, someone may make, under Section 30F of the Evidence Act, someone may make these statements in relation to the existence of a relationship by blood or marriage or adoption, whatever it is. Under this case, you may not need special knowledge, but you may say, according to the will. So you can come and say, according to the will, so and so said this is his property, or this is his child or beneficiary, whatever it is, and that is hearsay evidence.